What problems do franchisees face with contract renewal and transfer clauses? Imagine building a business that you hope to run 4 years, only to find out that your future plans might be limited by your franchise agreement. That's what many franchisees face when it comes to renewal and transfer clauses. These parts of the contract can seem straightforward but often hide some tricky issues. First, most franchise agreements do not promise automatic renewal. The franchisor has the right to decide whether to renew your contract when it expires. This means if your performance drops, or if the franchisor feels your location no longer fits their brand, they can refuse renewal. Franchisees often feel vulnerable because they might have invested years into their business only to lose it at renewal time. Next, renewal notices are usually very specific. The franchise agreement might requiring you to give written notice a certain number of months before the expiration date, often between 6 months to 1 year. If you miss this deadline or forget to send the notice properly, you could lose your renewal rights. Sometimes franchisees think they've given notice verbally or informally, but the franchisor insists they did not meet the formal requirements. Even if renewal is granted, the new contract might come with less favorable terms. The franchisor may increase franchise fees, change operational standards, or modify territorial boundaries. Franchisees might feel pressured to accept these new conditions just to keep their business running. This can hurt profitability and reduce control over how they operate. Renewal is also linked to lease agreements for the location. Often, renewing the franchise does not automatically mean renewing the lease on the property. If the lease terms are not aligned with the franchise renewal, the franchisee could face rent increases or even eviction, which disrupts the business. Transfer clauses can be just as problematic. Many franchise agreements restrict franchisees from selling or transferring their franchise without prior approval from the franchisor. The franchisor can deny a transfer based on vague or subjective reasons, making it hard for franchisees to exit or sell their business. This limits their ability to cash out or relocate, which can hurt the value of their investment. Sometimes, franchisors enforce transfer rules inconsistently. They might approve some transfers easily but deny others without clear reasons. This unfair enforcement creates uncertainty and can lead to legal disputes. Finally, renewal negotiations can be lengthy and complicated. Franchisees often need to prepare financial and operational reports, upgrade equipment, and review updated disclosure documents. Starting these discussions 1 to 3 years before the contract ends is essential. Failing to do so can lead to last-minute negotiations that result in unfavorable terms or even losing the franchise. In the end, understanding the details of renewal and transfer clauses early on can save franchisees a lot of trouble. Consulting legal professionals, communicating proactively with the franchisor, and planning ahead are key steps. Recognizing how these clauses interact with lease agreements and other contracts helps keep the business running smoothly during renewal or transfer periods.